Welcome back to the Legal Alternative Podcast with me, Sam Pawson. Joined us by Nils. Nils, how are you?
I'm good, Sam. How are you?
Yeah, just back. I think we're remote. It's my timings this week. Just back from relatively sunny Tenerife. A bit cloudy but warm. Lovely few days off, which means slightly delayed on recording of the podcast. But no, delighted to be back. Busy as always. Nothing you're kicking us off this week?
I am. It's an unusual topic, I think, for discussion.
Yeah.
But I think it's important because I think it's a mistake that a lot of people do make and could make.
Yeah.
So I suppose I'm going to put it in a local context and talk about the Bradford Clean Air Zone. I'm aware that scheme may apply to other cities and towns that people listening to the podcast live in. But there are certain areas of certain cities and towns whereby certain vehicles have to pay a charge if they go into a particular area, if they don't meet certain environmental standards in very basic terms. In the Bradford area, if you do that, there's a £9 clean air zone charge. If you don't pay that particular charge, then there's a penalty charge, £120. That's reduced to 60 if you pay within 14 days, and you've also got to pay the clean air charge as well.
Yeah.
In terms of, just to roll back a little bit, if you disagree with that decision, you can make representations to the council. That's got to be done within 28 days. And then if that's rejected, you can actually go to a different body, which is the Traffic Penalty Tribunal. I've only heard of them previously in relation to parking fines.
Yeah.
In order to appeal the council's decision. We've seen mistakes whereby people have disposed of vehicles and that process hasn't gone smoothly, and the vehicle has then been driven within the clean air zone. And they have received either a fine or lots of fines. And because it's a small charge, or I suppose it's not if you have to pay it every day, but £9 isn't obviously a huge sum of money. The fine, £120 or even £60. If you accrue a few of those, it starts to become a lot of money. As the registered keeper, it is your responsibility to pay that charge. So if you do not dispose of the vehicle properly by changing the registered keeper details, you are going to be liable. And if you've got someone who is driving about without a care as to whether they pay this charge, because either you have relied on them to change the ownership of the vehicle or you haven't done it properly, ultimately the bookie is going to stop with you as the person who is still the registered keeper. The whole system of identifying a registered keeper is so that authorities such as the council, the police, don't have to then go on a merry-go-round searching for people. So it's important that you don't just say to, if you're selling a vehicle for scrap, for instance, or transferring an older vehicle, which I suspect a lot of these vehicles will be, that find themselves in this scenario, you're not just handing over the keys and saying, you sort the admin out for me.
Yeah. The
responsibility is on you. Because we have seen it where somebody has got in a situation where they've got themselves a lot of fines despite thinking they'd dispose of the vehicle. So a minor on the face of it issue becomes a big one.
Yeah.
So yeah, I don't think there's much more I can say on that, really.
No, and I don't think I've got much. As you say, do your logbook properly.
Exactly.
It's one that gets a lot of flack in terms of in Bradford as a policy, one that isn't overly difficult to adhere to, I would suggest.
Yeah. Good stuff. I think you've got a really interesting case, actually.
Yeah, I've got an interesting case. Two real kind of headlines for me. Well, it's a pregnancy discrimination case, which is obviously we'll chat about. There's an issue of disclosure, and I often get asked on both sides of the claim and respondent divide about disclosure and professional privilege, which relates to your and I's work, Nils. So I'll just quickly talk about in a case that's just recently published. It case of Farmer versus Fresh Cut Video. Summary of the case is really the claimant has been awarded £73,000 as a result of a pregnancy discrimination case where she has worked from home due to acute morning sickness. So that's your headline. But let me delve into a bit more detail, because the detail is important in this case. I'll read more than normal from my notes. Claimant joins the respondent January 23 as a video editor. year later, January 24, she was announced that she was pregnant, informed the company of that, and informed them she would like to work from home, presenting a fit note saying that obviously she's been experiencing morning sickness. There is then a relatively convoluted period of conversations with her employer about both the sickness absence, the work from home, and what becomes a performance review. From the facts of the case, prior to informing the respondent that she was pregnant, by all accounts, the claimant was doing a good job. No issues had been raised with her performance. She's been given a bonus, and her work has generally been well received. After that, however, there are some suggestions that there is performance concerns relating to two things, really. One, her general performance at work, and secondly, her work from home. Where the respondent has got themselves into some difficulty is there has been a series of emails exchanged between the owner of the company, the HR manager, who happens to be the owner of the company's mother, that we see a lot, and a third-party HR consultancy that I won't name, but it is on. It's, if you go and look in the judgment, it is named in the judgment. I'll read some of the emails out because I think that they, which were disclosed, and I'll come into the relevance of the disclosure as part of the judgment. Email from the managing director to HR saying, time to check about that probation, not caring for an emergency call like that and telling me about it today at 7:20 instead of last night. Doesn't care at all. These referred to, again, calls and by the claimant that she has to work from home. Further emails then to I'll have to edit that out. Further emails, consultant and the HR manager saying, we've constantly made it clear to the claimant that the post was office-based with some work on location, but managing the commute has been challenged. In the meeting today, the claimant advised a fellow employee that she was pregnant and some additional health challenges that will necessitate her from working from home to time. The third-party HR consultant was then commissioned to carry out a disciplinary action into performance concerns relating to general performance and working from home. As a result of that, the claimant was dismissed. Under 2 years of service, claimant then brings a claim in pregnancy discrimination. Tribunal, for me, unsurprisingly, holds that the is connected to the pregnancy. In the judgment, the judge mentions that pregnancy is explicitly mentioned in the context of the main concern. Therefore, infer that the concerns about the role being office-based was significantly influenced and exacerbated by the disclosure of the pregnancy and her current sick related to that. The sick relation in relation to that pregnancy. Key bit of the judgment that I want to kind of pick out. So as a result, as I say, claimant awarded £72,000 in damages. Key kind of takeaways for me and findings is first in terms of that pregnancy issue and the explicit mentioning of that what a tribunal will do is as the judges say, is take that inference. So if there is a causal connection between a dismissal, someone's pregnancy, and some form of absence, that is going to be inferred that there is, because that is explicitly mentioned. If we are separating the performance concerns and the pregnancy, then the company may have a greater degree of success in defending such a claim. But there is a clear inference the claimant can rely on. One of the reasons the claimant can rely on that is because of obviously this information has been disclosed. Obviously, when a company, there is dialogue between, and you'll know this better than I, Nils, between obviously, in this case, the managing director and the HR manager, that would normally be picked up in some form of subject access request. What often isn't picked up is when you're involving a legal advisor. The difference here is that who the organization are using are a HR consultancy who, unlike professional advisors, don't rely and can't rely on professional privilege. So if this was an email to ourselves in seeking legal advice, that response from us wouldn't be obviously disclosable, because the client would rely on that professional privilege. The slight difference here, obviously, is then the organisation are used to commission the disciplinary and performance concerns. So that would all be disclosable evidence. But critically, some of these emails where this inference is linked have been disclosed. So a real clear lesson and takeaway from me for all of the listeners is, if you are seeking what you believe is legal advice, be very clear that you are doing that.
Yeah.
So you're not just copying in lawyers or advisors in day-to-day correspondence, you're actually seeking legal advice. And to check with your advisor if they benefit from legal professional privilege. Because often if they are unqualified and unregulated, they won't. So, we need to be really careful in doing that, because then everything you have disclosed to them is capable of being disclosed as part of the action. On the discrimination side, as I say, clear lessons to learn is to really, if there are performance concerns with individuals who are pregnant, one, to obviously take to kind of act extremely cautiously, but to make sure that we can distinguish issues that are not connected to the pregnancy to ones who are not. The absence being a really difficult one that was clear, and working from home that were clearly linked to the individual's pregnancy and morning sickness. So I thought an interesting case on two grounds. Nils, I don't know any takeaways from you.
I still know the answer to this. I would be interested to know whether it was the opposition, if you like, that said, please disclose this material, or whether it was voluntarily disclosed.
I won't be held to put on the stand to this, but my understanding from the case review, I think this was through a kind of subject access request that it's been obtained. So, as you say, it's going to be difficult. Obviously, that is your disclosure obligation, but it would be, again, another case that we'll probably both say it's. And we're surprised it's got to a hearing when there is such that clear inference made. But yeah, it's I think interesting on the disclosure.
It is. It's really interesting. It'd be interested to see whether HR providers lobby for a similar or same status as qualified lawyers. Because I would imagine that is now a significant problem. Because the HR providers tend to be quite large. No, not tend to be. There are some very large HR providers out there. And that would, I suspect, make a big difference to the way a lot of people corresponded.
I think so. I know some of those providers do have qualified practitioners as part of that organisation, but and that's why I think for this isn't about us, having a go at people using HR consultants. It's about checking with that consultant.
Yeah.
Do you benefit from privilege? Because otherwise we need to be kind of checking how we correspond with you.
Yeah.
As if, with the expectancy that this can be disclosed.
Yeah.
So always critical and good to check with your advisor.
Yeah. Really interesting. Yeah. Really interesting.
Good stuff. In terms of out of the office, I've just come back from holiday myself, thick into seminar season. We've got a flexible working seminar coming up in Huddersfield from the time of this is released, a week on Thursday. The details on the website. Still a few places remaining in our Huddersfield office. Should be an exciting event. Nils, I don't know if anything you're getting up to you want to report.
Yeah, looking forward to going up to our newest office. So going to have a look at the newest office that we're opening. I won't quite break ranks on where that is yet. So yeah, looking forward to that. Looking forward to a day trip tomorrow.
Perfect. So lovely to be back as always. Back in your ears, hopefully in person together next week. But it's goodbye.
And from me, take care, everyone.